All right, guys, welcome back. We will now continue with the Race and Criminal Justice panel. Bridgette Baldwin is a professor of law at Western New England University School of Law. She teaches in the area of criminal law and procedure, international criminal justice, cybercrime, evidence, critical race theory, and race in the law. Her scholarly work has examined the intersection of the Ninth Amendment and social movements and topics which discuss the convergence of race, class, and gender on welfare reform legislation. Dr. Baldwin is also a certified DEI facilitator. She has conducted numerous trainings on microaggressions, unconscious bias, and culturally responsive teaching for both public and private companies. Dr. Baldwin also worked as a staff attorney for the Criminal Defense Division of the Legal Aid Society in New York City. She later became a staff attorney for the Bronx Defenders in the Bronx, New York. She worked as an in-house counsel for a major insurance company and with the law firm of James P. Noonmaker and Associates. She earned her JD from the University of Wisconsin Law School and her PhD from Northeastern University Law Policy and Society program in 2010. Her dissertation was entitled Wisconsin Works: Race, Gender, and Accountability in the Workfare Era. She has been a member of the Hampden County Lawyers for Justice since its inception in 2010 and was recognized for her outstanding achievements in the category of social impact at the 2023 New England Legal Awards. Please welcome Dr. Baldwin.
Thank you so much for that gracious introduction. And good morning, everybody. What a powerful keynote remark by Richard Rothstein. And again, welcome to the Color of Law Symposium and the session on race and criminal justice, two very important topics. So I'm here today to introduce you to three wonderful colleagues and experts in the area of criminal law. I would first like to introduce you to Professor Jack Chen. Jack Chen is the Edward L. Barrett Jr. Chair and Martin Luther King Jr. Professor of Law at UC Davis School of Law. He writes about criminal procedure, immigration, and Asian Pacific American legal history, and regularly appears on the list of the most cited legal scholars. Before entering law teaching here, before my time, but definitely has a reputation as being a wonderful colleague at Western New England School of Law. He clerked for U.S. District Judge Richard P. Mash in Denver and practiced with the law firm of Skadden and Arps and the Legal Aid Society of New York. The title of his talk is Desegregating Criminal Law. Our next speaker after Professor Chen will be my colleague, Professor LaJuana Davis. Professor Davis teaches criminal law and procedure and evidence at Samford University, Cumberland School of Law in Birmingham, Alabama. She's also a co-director of the Cumberland Innocence Clinic. Before joining the Academy, Professor Davis worked as an attorney for the Equal Justice Initiative of Alabama in Montgomery, specializing in direct appeals and state and federal habeas litigation. Her research interests include criminal procedure, education, and the right to counsel, and she and I are co-authors on an e-learn. The title of her talk is Should the Federal Rule of Evidence's Prior Conviction Impeachment Rule Be Saved? And our last speaker of the session, but certainly not least, is Professor Deborah Ramirez. Professor Ramirez is a tenured professor of law at Northeastern University School of Law, where she has taught criminal justice and a myriad of upper-level courses, including advanced criminal procedure, professional responsibility, race, justice, and reform, and seminars on the role of jury in a democratic system. Professor Ramirez's current areas of research are focused on reentry services and public safety. She also founded the Criminal Justice Task Force, currently housed under Northeastern University School of Law's Center for Law, Equity, and Race. Professor Ramirez will be discussing the Jail to Job Pipeline Project. Please join me as we welcome our speakers for this session. Professor Chen.
Thank you. It's a tremendous pleasure to be here among so many former legal aid society lawyers, colleagues at various places. It's a real pleasure. I am going to share my screen if I can. Can you see my slide?
Yes.
Great. Thank you. So my talk is called Desegregating Criminal Law. And I have three propositions for you. The first is that the United States never did anything systematically to root out, to uncover and repeal facially neutral but discriminatory laws. Second proposition is that it's a big problem and a major contributor to racial inequality in the criminal justice system today. And the third proposition is that there should be an obligation for jurisdictions to take a look at their criminal codes and determine which parts, although facially neutral, were actually motivated by a desire to discriminate on the basis of race. Obviously, I'm going to only be able to touch on some of the highlights of our history, but I will try to get the argument across as quickly as I can. I'm sure almost everybody here is familiar with the reality that there's a tremendous racial disparity in the criminal justice system. People of color are much more likely to be incarcerated. Over the last 30, 40, 50 years, there's been a huge increase in incarceration. It's leveled off. The scope of the criminal justice system is not limited to incarceration. It also includes vast networks of pre-conviction and post-conviction supervision. So millions and millions of people are caught up in the criminal justice system, and they're disproportionately people of color. I propose to you that a lot of that has to do with a racially discriminatory history. In the bad old days, before the Civil War, many criminal codes explicitly drew lines on the basis of race. And so some crimes were only applicable to people of color. Some crimes were subject to higher penalties if the person who committed the offense was a person of color. Rape by a person of color on a white woman was punishable in a way that other crimes, as serious as they may be, committed by other people against other victims were not. This was not only the South. You know, the South, stereotypically, the former Confederate states, has this racial history, which is true, the slave states. But in non-slave states, it was also the case that lines were drawn on the basis of race. This is California. Indians who didn't live up to the standards of the white society were subject to being grabbed off the street and sold into forced labor. What about other people? Well, we don't need a law for them, said the people of California. It's Indians that are the problem, and so this law will only apply to Indians. The reason for this, I think, we see from places like Connecticut that are supposed to be a non-slave state that is supposed to be progressive. Well, the Supreme Court said in plain language, people of color are not part of the social compact. The law is to control them, not for them to make and participate and benefit them. So then we had Reconstruction, 13th, 14th, and 15th Amendments. Big changes. I'm not going to deny it. There's a lot of happy talk about how this was a big change in the attitude of society. But in the criminal justice system, anyway, it didn't really work out that way. It didn't work out that way. There might have been some high-minded ideals, but it certainly did not result in a systematic change in racial targeting of criminal law. And so In this article, Professor Holloway at the University of Richmond wrote about how in the South, the criminal law and the disenfranchisement law was altered throughout the South to provide that offenses allegedly committed by Black people would result in disenfranchisement. And the law was deliberately rigged to do what it could to prevent African Americans from voting in the South. This was a fairly systematic effort. And so we see this case from the Mississippi Supreme Court in 1896, long after Reconstruction, long after the passage of the 14th Amendment and its promise of equal protection of the laws. And Ratliff versus Beale was a tax case, not anything criminal justice related, facially neutral. But the Mississippi Supreme Court in 1896, which included a number of people who participated in drafting the Mississippi Constitution of 1890, explained the background of this particular tax law, facially neutral tax law. And they said, look, the problem was that after the Civil War and the 15th Amendment, which prohibited discrimination in the right to vote on the basis of race, a majority of the people of Mississippi were Black, but, says the Mississippi Supreme Court, they really were not prepared to be voters, to be in charge. And so, you know, in America, the majority is supposed to rule, but this particular majority was not capable of ruling. So they really weren't going to be allowed to rule. And so the white minority engaged in what the Mississippi Supreme Court calls a semi-military, semi-civil uprising under which the white race, inferior in number, but superior in spirit, in governmental instinct, and in intelligence, was restored to power. So what do they do then in light of the fact that the 15th Amendment prohibits discrimination in the right to vote and in other areas on the basis of race? And they say, the Mississippi Supreme Court explains that the Mississippi Constitution of 1890, within the field of permissible action under the limitations imposed by the federal Constitution, swept the circle of expedients to obstruct the exercise of the franchise by the Negro race. Restrained by the federal Constitution from discriminating against the Negro race, the convention discriminated against its characteristics and the offenses to which its weaker members were prone. And so they created new laws, facially neutral, but targeting African Americans. And they used these laws to disenfranchise African Americans and ensure that the white minority would be able to control the electoral process. And so what did the US Supreme Court have to say about this? What did the US Supreme Court have to say about this? Well, in Mississippi, as in many other states, then and now, in order to be a juror in civil and criminal cases, you have to be an elector. You have to be registered to vote. And if Black people in Mississippi were denied the right to vote, they were also denied the right to sit on juries. And therefore, the one consequence of the Mississippi Constitution of 1890 is that the juries were all white. And that meant that people of color charged with crimes were faced with all white juries. And a fella named Williams was convicted of a crime and sentenced to death, and he appeals to the Supreme Court and says, hey, all white jury, you know, look what's happening here, and look at Ratliff versus Beale, where the Mississippi Supreme Court says they have done everything they can to keep white people, to keep Black people from voting and therefore from serving on juries. This is unfair. And the Supreme Court says, you're misunderstanding the situation, Williams. It's totally fair, completely fair. Because it is, they said, the US Supreme Court says, they're discriminating against Black people within the field of permissible action under the limitations imposed by the Constitution. They're complying with the Constitution as they dismiss Black people from the voting rolls. And they say the language, more importantly, the language of the laws is neutral. Everyone who steals a chicken is disenfranchised and therefore can't vote. The US Supreme Court says the laws reach wicked and vicious white men as well as weak and vicious Black men. And whatever is sinister in their intention, if anything, can be prevented by both races by the exertion of that duty which voluntarily pays taxes and refrains from crime. So if a state or a number of states come up with laws that are designed to discriminate against Black people, then the solution is that Black people should just obey those laws. The problem is, one problem is the fear that a government that comes up with laws that are designed to disenfranchise Black people might enforce them unfairly, as of course happened in many southern states and other states, but it's hard to prove. But the doctrinal point that I want you to take from this is that even after Reconstruction, even after the Civil War, we get a major change in that facially discriminatory laws, like ones that have different penalties and different obligations for people of color than for whites, they're unconstitutional. Okay, you can't say Chinese people can't use opium, but other people can. That's unconstitutional. You also can't have a facially neutral law that's discriminatorily applied. That comes from Yickwo versus Hopkins, says the Supreme Court. But it's virtually impossible to prove that a facially neutral law is discriminatorily applied. And the big problem is that a facially neutral law that's discriminatorily motivated is constitutional. That's the rule of Williams versus Mississippi. If the legislature wants to figure out a way to disenfranchise a particular race or religion or ethnic group or color, they can do so, says the Supreme Court, so long as it's facially neutral and there's no proof that it's discriminatorily applied. What I want to say about this rule, which doesn't exist now, is that morally and legally, there was no disjuncture. There was no moment where all of a sudden this changed, legally or morally. And the moral part of it is after Brown versus Board of Education in 1954. There was no, from what I see, sort of national soul searching, where the country as a whole said, you know, we've been behaving very badly, and this should change. And what we need to do is stop discriminating on the basis of race. Instead, you see things like the Southern Manifesto, 2 years after Brown versus Board of Education, where 98 senators and representatives said Brown was a dreadful mistake, it's unconstitutional, it should be changed. And people who oppose it and don't want to comply with it, they're in the right. Another piece of evidence that I see for this is 10 years after the Southern Manifesto, another decision of the Mississippi Supreme Court in Knight versus State, which upheld the conviction of some freedom riders for not leaving a segregated bus station that they were visiting as a protest, and they were attacked by a white mob. And the police, instead of protecting them from the white mob, said, "Look, you're causing trouble by white people and Black people being in the same room, and so you all have to leave." and they declined to do so because they felt they had the right to do so under federal law. And they were arrested and convicted of crimes, and the Mississippi Supreme Court affirmed their convictions, ultimately reversed by the US Supreme Court. But in affirming their convictions, the Mississippi Supreme Court said, look, you people have to understand the nature of the dedication to segregation. And they said, an elected Supreme Court, so these are people who have some connection to the community. These are not critical race theorists, these are white men. And they say that the dedication to segregation, in many instances, goes as deep or deeper than religion itself. Okay? Christianity is great, it's important, it's one thing. Segregation, says the Mississippi Supreme Court, is more important, according to a lot of people. So there's no moral repudiation of political, social repudiation. There's resentment and resistance to the idea of racial equality. And legally, as late as 1971, the US Supreme Court says that discriminatory motivation does not necessarily invalidate a facially neutral law. Palmer versus Thompson involved a city that was ordered to desegregate its public facilities, swimming pools, and instead of desegregating its swimming pools, it filled them in with concrete. I thank Josh Blackman for this photograph. I stole it from his website. That's a photograph of a filled-in swimming pool from Jackson. And the Supreme Court says, look, Jackson might have closed the swimming pools in order to promote segregation, but closing the swimming pools is facially neutral, and we can't invalidate a law that's facially neutral just because it's badly motivated. Now that a lot of laws on the books today have this quality. Laws prohibiting carrying weapons. The Florida Supreme Court said, or the Chief Justice anyway, said the statute was never intended to be applied to the white population, and in practice never has been so applied. The Undesirable Aliens Act, which criminalizes re-entry after deportation in federal law, has a tainted racial history. The Mississippi Constitution's disenfranchisement provision. But with regard to the Undesirable Aliens Act, with regard to the Mississippi Constitution of 1890, courts today are declining to find these invalid. Not because the law hasn't changed. The law has changed, and discriminatory motivation does invalidate a facially neutral law starting in 1977. But courts engage in all kinds of machinations and gymnastics to say, well, it might have been discriminatorily motivated when it was enacted. But gee, in 1953, it was renumbered. And in 1965, the language was changed a little bit. And so now, is it discriminatory? And we don't think that it was. And so laws that were discriminatorily motivated nevertheless survive the tests of current equal protection jurisprudence, and we live with them today. And my proposal, which I will articulate very briefly, is that the legal doctrine should require the states to go back and the federal government to go back and take a look at these laws. The Supreme Court has recognized an obligation to govern impartially, and racially selective laws, I think, violate that obligation. With regard to segregation of schools, they've said there's an affirmative obligation, an affirmative duty to desegregate, to look at the bad things, the racially unconstitutional things the state has done, and undo them. And in upholding the originally racially discriminatory laws that have survived judicial review in the last few years, the courts have not asked, did the state do a purge? Did the state at some point say, we're going to look at whether these facially neutral laws were in fact motivated by racial discrimination? And if they were, we're going to at least consider whether to get rid of them. We're at least going to consider whether it's time for them to go. And I think that should be a requirement, or at least a factor in determining whether these laws are no good. And if there is a historically discriminatory law that's still on the books, even if it has been renumbered and amended in certain ways, I think the question of whether the state has indicated that it takes seriously its obligation to govern impartially should be an important consideration in whether it survives equal protection review in 2023. Thank you.
Thank you so much, Professor Chen. I think what we should do is perhaps hold the questions for everybody, the entire panel, until the end, so that everyone gets the opportunity to present. I would encourage those on the webinar to put questions in the Q&A, and those present in the live audience to provide questions to Andrew. It's my pleasure next to introduce my colleague, Professor Davis.
Wait, did I get cut off here? Or am I? Oh, good.
No, you're there.
Good, thank you. Hello, I am LaJuana Davis. Thank you to Dr. Baldwin, and of course to the staff and the editors of the Law Review Symposium. Y'all have done an amazing job, so thank you very much for inviting me. This little talk is about a small rule with a big impact. And the first part of this, a lot of you are going to be very aware of. You may even remember this mini review of your evidence class about this small rule. But this small part of Rule 609, the prior conviction impeachment rule, is really more of a high stakes rule than we might ordinarily think of. First of all, it is the second most often used rule in the rules of evidence regarding character evidence. And so it is impactful in that way. But I argue, and of course, building on the scholarship of many others, that this rule is pivotal, both to whether defendants will elect to get on the stand, even innocent defendants will elect to get on the stand and tell their story, or whether or not defendants will go to trial at all. Though you guys may remember from your evidence class that Rule 609 is really a legacy of the common law, and really it was a rule of competency of witnesses. And essentially it said felons are barred from testifying. And then, of course, as we progressed through United States law, we began to alter that rule. I argue, again, standing on the shoulders of many others, that rule maybe is at the end of its usefulness, and particularly given its racial impact on the criminal justice system. So basically, the premises of this rule is the same premise of much of the rules of evidence, which is it's a construct of psychology. What do we think as rule makers people will do with evidence that they are given? How do they receive it, store it? What will they use it for when it comes time to draw inferences and decide whether or not somebody's guilty or not? And so 609 is part of that psychology of the federal rules of evidence. And essentially it says, once a defendant witness takes the stand, he or she opens themselves up for impeachment, for credibility by the prosecution, and who will often introduce evidence of their prior convictions. And so that is a subset of this rule, 609 generally, which is 609A, 1B, right, where the witness is the defendant. And from the beginning, from the onset, the members of Congress and the people who proposed this rule were very aware of the prejudicial nature of this rule. It was almost like, throwing a lightning bolt into the middle of the trial. Because as you remember from the federal rules of evidence, it's all about making sure that people are not judged on their character or propensity to do something, that they are actually judged on the evidence that is coming into the courtroom and is legally admitted. But this is a departure from that. And in that departure, the rule makers realize, okay, this rule is so big, such a big deal, and so potentially prejudicial that we've got to put limits on it. So I'll just run through those limits really quickly. Again, we're just talking in this section about the rule that applies to criminal defendants who testify on their own behalf. And again, the assumption behind that is somebody with a felony cannot be trusted to tell the truth in court. And it's a very different idea and presentation than the rest of the federal rules, including 404B, which has all of these requirements before a bad act can be used against someone. A second big premise of 609 is that this rule is only offered to attack witness credibility. So the jury can only consider it for that purpose, which leads me to number 3, which is they're absolutely not doing that. Jurors are not able to limit their consideration of a criminal conviction. And there have been a number of great studies done over the years, starting all the way back before the full rule was actually implemented, called the American Jury. And that rule in study in 1966 showed that that when evidence of a prior conviction or knowing that the defendant had a criminal record, given a constant fact pattern and everything the same, jurors were 27% more likely to convict that person. Same evidence across the mock jury panels that they created all the way back in 1966, again, before the enactment of this provision. We've always known that. We've always known that jurors have a very hard time understanding legal instructions to them at the end of a trial, and telling a juror that, oh, we've got this great evidence that you would normally rely on if you were looking at social media, but don't think about it now. Don't look at it now. As one author said, is like saying to the jurors, don't look at that pink elephant in the middle of the courtroom. Ignore that. And so we've always known the risk and the problems. And of course, the risk is that the defendant appears to the jury and the judge as a bad person. And the fact finder is going to convict on that basis rather than whatever evidence came in to the courtroom. Second problem, of course, is that a juror can also use this, and we're talking about the defendant now, but how this rule also plays out for those of you evidence fans is also it plays out for the defendant's witnesses who he or she may present. Again, if this person has prior convictions, the jury may use it as character trait evidence for committing certain types of crimes. The rule makers knew that this was so serious that they tried to create balancing tests to try to kind of rebalance the problems there. So there are a lot of distinctions in the rule to try to limit the amount of damage that this rule does. I argue that even these factors that we tried to create, all these distinctions that we created about what kind of crime was, in other words, if it more tends towards violence, it's less probative of truthfulness. If it's too long ago, maybe we don't want it. If the crimes are too similar, it's too prejudicial, judge should consider leaving it out. And if the importance of the defendant testimony is high, for example, if they have an alibi, we ought to rethink when that we ought to admit that. And of course, if the defendant's credibility is key to what is happening in the courtroom, maybe we ought to reconsider keeping that. Nevertheless, with all of these considerations, again, the second most kind of used character rule in the rules of evidence. And so let's talk about very briefly about how this rule got here, why we made the decision to have and keep this rule. So as I mentioned, this rule grows out of a now rejected idea that a witness is totally incompetent if they had a prior conviction, and that was universal, blanket. So it wasn't a felony, didn't have the felony rule that we have now in there. And I wanted to talk a little bit about the 1860s and when the rule moves to use, a widespread use in the United States, because there is an interesting racial link to the use of what is now called 609 with respect to criminal defendants after the Civil War. And what happened was the Southern states sort of attacked the Northern states, saying, well, you guys are hypocrites because you exclude Black people from testifying in trials, and you've still got these competency rules barring criminal defendants from testifying. And so why are we wrong for saying Black people can't testify at all if you have rules that say these people with these prior convictions can't come and testify as a witness or even in their own defense? And so some of the rules began to soften when that attack or that critique came. And it really is, it was interesting because it came from Southern states reflecting sort of this white supremacy, getting Northern states to say, oh, well, all right, we'll start to, look at our rules, make sure that we don't have a blanket rejection of witnesses testifying. And then, of course, the federal rules are enacted. And in 1975, this rule comes to the forefront. And initially, this provision of 609 did not have this particular provision. In other words, it did not have A1B, but a sponsored amendment by a Senator McClellan of Arkansas, joined by various senators, made a persuasive pitch to Congress and to the rule makers that we've got to have this rule in here. And interestingly, the argument that he makes is a straight up propensity argument. It was not hidden at all. And for us to now kind of look back at the theory of 609 as this is not a propensity rule, in fact, it really is. When you look back at the arguments that were made about this rule and essentially saying when you're convicted of a crime, you ought to be able to bring in this evidence because it will help law enforcement. And so let's go on to some of the critiques and sort of the challenge of this rule generally, right? In other words, throwing the baby out with bathwater. And what this quote is from Professor Carradine is really a quote about the compound interests of racial injustice, is what I call it, right? It's what Professor Chen was just talking about, right? We are aware about the statistics, about the way that people come into the criminal justice system, particularly minorities, ethnic and racial. And there are a lot of compelling theories about the disproportionate number of incarcerated minorities because of the over-policing, because of the war on drugs, because of bias within the system and other flaws and biases in the trial process that often end in minorities getting harsher treatment than non-minorities, or sometimes even having innocent people convicted for things. And that led her and a lot of people to look at this and say, ultimately, this is operating in a racial manner, because the people who are being subject to this are more likely to be Black and brown, and you are essentially, and other, quite frankly, other races and ethnicities, by the way, as well, because this they've done some of these studies across the world, and it's showing up in other countries too. We're not just the only ones. And ultimately, it sort of leads back to, why are we holding on to a rule that was suspect at the beginning? And now we don't have a lot of evidence. We have a lot of evidence that is being misused. We don't have a lot of evidence on the other side that is not being misused. And we know that it has a severe, as I say, racial compound interest on people in the criminal justice system. And so the part of the concern about this rule obviously is the danger of misuse, but we've always been focusing on the jury. Now, I think we're now stepping back and saying perhaps the real danger of misuse is that prosecutors and people in the justice system are aware that people will misuse this, and there are very few criminal defense attorneys that I know that would not seriously and carefully consider whether they would put a defendant on the stand, and would also deeply consider whether or not, if they had a witness who was a favorable defense witness, whether or not they would put that person on the stand, given this rule. And so that's what I call, or the obvious danger of misuse. That we know we've got racial bias within the system. We know jurors can't use this information, in any kind of way that it was meant to be used. And we know that prior convictions ultimately make very quickly morph into you're a bad person, and therefore we are doing this. So why abolish this rule? Why do we now we have increasing arguments to say just get rid of it? One, we don't have a lot of evidence of its probative value. There are various studies that have been done with mock jurors, even with children, and lying. And our ability to tell who somebody is lying is almost nil. And our ability to predict that someone is lying from their previous behavior is also not supported by the science. Quite frankly, the science says it's so specific in terms of somebody's decision to lie that it's not necessarily based on who they are when they came into the courtroom. And its effect both on the decision to testify and the decision to go to trial at all is obviously troubling for a justice system where we're trying to give everyone the same opportunity. And of course, it is a bonus round for plea bargaining, because once you know I don't have a strong way to present myself or to present witnesses in support of me, you are more likely to just say, okay, forget it. The system will not work in my favor. Just a quick kind of a look at this rule. Like I said, a small rule with a big impact that is troubling and may encourage us to, as Professor Chen talked about, to go back through all of the rules and see how they started and do we now support what it is that we're doing. By the way, the states that have gotten rid of this rule after some initial, trying to figure everything out, they've been fine. there's no big deal about getting rid of the rule. So thank you very much for allowing me to come and to speak to all of you. And I look forward to Professor Ramirez.
Thank you so much for that informative talk. I encourage the audience to please put some questions and answers. I'm sorry, not answers. Put some questions in the Q&A so that our panelists can enlighten us further. Without further ado, I introduce you to Professor Ramirez.
Good morning, everyone. Thank you to the folks at Western New England Law School for inviting all of us and convening us for this important symposium. One of the topics that we've been addressing today is the way that explicit government policies at the state, local, and federal level create racial disproportionality and racial inequality. And this includes a lot of facially neutral laws that were discussed earlier. In the criminal justice, my research has focused on both the causes and triggers of mass incarceration and of racial disparities in the criminal justice system. During my long research odyssey, I've focused on issues of racial profiling data collection, jury selection issues, pretext traffic stops, sentencing disparities, and the effects of minimum mandatory sentences, which are, of course, facially neutral laws, which disproportionately affect the community of color. So I was very interested to hear what the Council on State Governments would say when they came in to assess our criminal justice system here in Massachusetts. Now, as many of you know, I was married to Chief Justice Ralph Gantz, who died 3 years ago. While he was alive, he asked the council to tell him what were the most important problems that we in Massachusetts were facing in terms of our criminal justice system. And the council said that the number one problem we should be concerned about with our criminal justice system, and frankly, with most state criminal justice systems, is recidivism. How many people return to the system after incarceration? In Massachusetts and in many states, the answer is that 75% of those folks who leave prison and jail are going to return within 5 years. The council believed this was an economic problem because it cost the state $50,000 a year to reincarcerate these folks. But it was also a trigger for mass incarceration, because if 75% of the people who left never returned, we would have a much lower prison population, as would every state. And it contributes to racial disparities because disproportionately, those who come back into the system are people of color for an enormous number of reasons, including lack of resources during the reentry process. Both Ralph and I were really embarrassed and kind of devastated by this assessment of our system. And I began to think about how to address it. I had a deep conversation with one of my friends, and he said, focus on reentry. And I replied, why focus on the end of the process? Shouldn't I be focused at the beginning of the process about how to ensure people don't get incarcerated in the first instance? And he said something really important to me. He said, Debbie, it's not a linear process with a beginning here and an end here. He said, it's a circle. So it doesn't matter when you intervene or where. And intervening when they leave prison or jail could be the most effective intervention point, because at that moment, the person stands by themselves. There is no police officer, judge, defense counsel, prosecutor, or victim to oppose whatever efforts you want to make to intervene. And that, it was a great epiphany. And it was the reason why I began to focus on reentry. So I began to think about reentry as a way to break the cycle. How could we provide every person coming out of jail or prison with the resources they would need to create a productive life? And in terms of racial disparities, this would be especially important for those who were people of color and who didn't have family resources, family money, or a way to navigate the reentry system. My first thought was to create a pilot program in Brockton. With the help of Angel Kelly, who was the regional assistant judge there, we began to think about it. She's now a federal district court judge, and I began to think about raising money for a reentry program in Brockton because they didn't have one. I discovered a lot in the process. First, I learned that Massachusetts and almost every other state has a reentry network that consists of a patchwork of privately funded, uncoordinated entities that vary in focus and efficacy. For example, in Lowell, there's UTEC, which is doing God's work, but they only work with 18 to 24-year-olds who are gang involved. Then there's ROCA, that's in Springfield as well as in Boston, but they only work with the worst of the worst, people who have multiple and severe convictions. A place called Wiser helps folks in Worcester. There's Catholic, Muslim, Jewish reentry networks. Second, I discovered that all of these reentry networks spend 50% of their time and energy fundraising. And third, I learned that those that survived were not the most efficacious, but the ones that were the best at fundraising. And this has two effects, and they're important. One, those folks coming out of prison and jail have a hard time figuring out within this uncoordinated patchwork of reentry entities where they can get reentry services when they come out of prison and jail. And second, employers who want to hire those folks coming out of prison and jail have to navigate a myriad of different protocols with a myriad of different private reentry networks. So I knew that what we needed was one-stop shopping for both ex-offenders and for employers. Also, I learned something painful. I am a terrible fundraiser. I failed to raise the $150,000 that we needed to start our Brockton reentry program. So I took a deep breath and I started to think hard about how to affect structural change in this arena. I realized that another privately funded Brockton reentry program probably wasn't the solution. It is the state that's going to save money every time someone doesn't recidivate. And so I figured the state should create a statewide, state-funded reentry network. And the state could then provide the one-stop shopping for ex-offenders and for employers. Meanwhile, back in Brockton, at the Brockton Pilot Programs Roundtable was the Office of Community Corrections. They told me they had a problem. They were a state entity that reported to probation. They were part of the court system. They said they were underutilized. They had 18 offices, $25 million, but the judges weren't using them. Could I help them craft a marketing strategy to educate the judges about their services? But I discovered they were using really punitive methods that were more expensive than probation. And mostly, they ended up violating people and putting them back in prison or jail. So I asked Ralph, whether their offices could be repurposed to become a statewide, state-funded reentry network. He said, the matter is legislative because OCC was created by the legislature to do intensive probation for those who had not succeeded during the first probationary sentence. And he did not have the authority to repurpose their underutilized resources. And that meant I began a legislative odyssey. In time, Senator Will Brownsberger agreed to help me. With his assistance and the help of so many other people, we convinced the legislature to repurpose OCC's resources to create a statewide, state-funded reentry network. Now, when Ralph saw that the legislature passed that item and that we had the first comprehensive state-funded reentry network in the country, he said, and he used to talk like this is big. He said, you have to stop everything you're doing and focus on this. I told him, I have other stuff to do, but I would also figure out how to help OCC harness the full strength of this new model. After Ralph died, I asked the legislature to create the Chief Justice Ralph Gantz Reentry Fund. I told them that the children and I were adamant that we did not want a courthouse with his name on it, a park with his name on it, a building with his name on it, or a street with his name on it. We wanted his legacy to be this fund so that it would continue the work that he and I started before he died. Thankfully, with the help of lots of folks, including Will Brownsberger, the legislature created a $2 million fund that would each year provide OCC with funds to hire reentry coordinators for each of the 19 OCC offices. And then, and to me, this was big, we renamed it because I didn't like Office of Community Corrections. We renamed it to call it the Community Justice Support Centers. Doesn't that sound better? And today we have a budget of $30 million and 19 offices. Its mandate is to provide reentry services to every person coming out of prison or jail, regardless of probation or parole status. That's the sentence that Will Brownsberg and I wrote into the budget. What does it mean? It means every person, federal or state, every person, whether they're on probation, whether they're on parole, or whether they've wrapped up their sentence, served their time, and are standing all by themselves without probation or parole help. Every person can get resources at this network. So what kind of services do we supply? Each office has a public benefits coordinator to help folks access Mass Health, SNAP, SSI, SSDI. Each office has a reentry coordinator and a jobs coordinator, some of them with lived experience who have themselves navigated the reentry process. That was big too, beginning to hire people with lived experience, not just professional court people who are very good, but who don't have the lived experience that people who've actually had to navigate this labyrinth have. We help people get photo IDs, jobs, job training, housing, substance use disorder treatment, mental health services, and navigators and mentors. We also help them get access to private reentry programs. We tell them everything privately that's available and that's available next to one of these 19 offices, and also the stuff we have, because we have emergency housing, contracts with the YMCA for housing, things like that. My current focus is on the jobs to jail pipeline. We know that the number one factor in determining whether someone is going to be successful during reentry is whether they get a job. And I'm trying to connect the employers who need labor with the folks coming out of prison and jail who need jobs. We actually have a global labor shortage that is not going to abate anytime soon. And there are 4 reasons for this. Baby boomers, like me, I'm 68 years old, are retiring. There's significant underemployment by folks who have dropped out of the labor force to care for children, elders, and loved ones. 3rd, Trump turned off the immigration spigot. And 4th, the global birth rate has dropped. None of these trends are likely to change in the near future. So if we're going to solve the labor shortage, We need to engage marginalized populations who've been locked out of the labor force. And I'm focused on developing the infrastructure and architecture to create jobs for one of those marginalized populations. And that population is those coming out of prison and jail. So I want to leave all of you with a plea for help. I am creating outreach and education programs for 3 groups now. 1, to educate the prisoners about community justice support centers so they can take advantage of the resources upon their release. I'm trying to educate employers about how to hire those coming out of jail and prison. And I've connected with the Boston Chamber of Commerce, the Private Industry Council, and the Associated Industries of Mass. And I'm trying to recruit volunteers to mentor and navigate folks who need help when they first come out of prison or jail. We have virtual training modules for folks who are interested and in helping one person during the reentry process. Finally, we always get calls for lawyers and trained law students who can help those reentering with a variety of legal issues, sealing criminal records, child support, alimony, tax, other concerns. So if you have any advice or suggestions, or you want to help with this enterprise, let me know. In conclusion, I want to say that as lawyers, we play a lot of different roles in the criminal justice reform movement, including identifying problems, which all of the people here have done. I have tried to focus on creating structural changes that would disrupt and reduce mass incarceration and racial inequities. Structural change can be really hard because it involves cooperation and coordination between the executive branch, the court branch, and the legislative branch. And it's a challenge to keep them informed and engaged. But I hope all of us begin to think about structural changes that will make the system fairer and more just for everyone. And I want to share what I learned from this project. Structural change is a long game, folks. It takes years to accomplish real structural change. But it can begin as it did with 2 people sitting over coffee, Angel Kelly and myself, working together. Third, we spent months creating a roundtable with people whose feet were on the ground to advise us how to do this. We had 40 or so people gathering monthly. They were people with lived experience, private reentry providers, healthcare experts, the mayor's office, defense counsel, prosecutors, social workers, criminal justice reform advocates, folks from OCC, community members, interfaith community people. We met for over 18 months. And at first, I was unsure we were making any progress at all. And after 18 months of meetings, I failed to raise the money necessary to launch the pilot in Brockton. A disaster, an utter failure, embarrassing. But out of that failure was born this project. So don't be afraid to fail. Failure is your best teacher. And I wanted to end with this African proverb because it highlights the importance of creating a large collaborative roundtable to address structural problems and create structural solutions. Instead of going to a library by myself and researching, I went to Brockton for weeks and learned. And this quote was meaningful to me at the time and now. It says, if you want to go fast, go alone. But if you want to go far, go together. If I learned anything from all of this, it is that it really does take a village to effect the changes that all of us know are needed. Thank you, everyone, for your attendance, and I welcome questions.
Oh, wow, this has been amazing. We have a little less than, I guess, about 10 minutes for questions, and we do have 2 in the Q&A. I would encourage those online and those in the audience, please, to provide questions. So let me start with the questions online. I can't see any, despite being in the building. I can't tell who's online. I mean, in the person. So I'm going to need assistance in the room for the questions there. But this first question is for Professor Chen regarding facially neutral laws. Do you think that the California's 3-strike law was inherently a facially neutral law as well?
Well, the three strikes law obviously is facially neutral in the Williams versus Mississippi sense, in the Palmer versus Thompson sense. I do think that the three strikes stuff is associated with race, but it is not the first line of things that I'm talking about. What I'm interested in at least starting with is, can't we agree that the sort of historical Jim Crow era stuff should be looked at skeptically, and we haven't even crossed that threshold yet, and so three strikes, sort of like the powder cocaine, crack cocaine disparity in the federal sentencing guidelines, is tinged with race, and when these things were passed, there's racially coded messages and arguments, and you can see that the folks that are passing these laws have people of color in mind as the defendants who are going to be affected by it. And I do think that those are problematic and should be gotten rid of. But what I'm trying to say is, at least when we look at something like the undesirable alien law from 1929, where they say we've got to do something about Mexicans, where they say the Section 241 of the Mississippi Constitution of 1890, where they say the purpose of this is to disenfranchise Black people, and we haven't even, the doctrine doesn't even allow those to be struck down. If there's any argument that somehow, gee, in 1972 they changed the numbering and they didn't, and there's no evidence that the legislature in 1972 was discriminatory, so it's fine. And if we can't even get rid of those, then we're not ready to talk about getting rid of the three strikes law. Although in California now there is the state law, as Professor Rothstein, or maybe he's not a professor, as the great scholar Rothstein said, states and localities can do things too. And California has passed a Racial Justice Act that says if there's racial disproportionality in the application of a law, then it can't be applied. And so, there are other ways to get at things like the three strikes law and the crack cocaine disparity, if there's interest in a locality to do so.
Thank you very much. We have another question online for Professor Davis. Has a majority of the states done away with Federal Rule of Evidence 609, and is there a noticeable trend in that direction?
Yeah, great question. Answer, no. 37 states basically adopted 609 in full from the federal rules, which just makes it so devastating, is that the street crime, which is normally the bread and butter of the states, this rule is actively being used. Another 12 made minor tweaks to the rule, maybe have a little bit more, a few more kind of ways to try to lessen the prejudice to defendants. But only three states have made a significant change to 609. That's Hawaii, Montana, and interestingly, Georgia have done some things where they have either abolished the rule altogether or have done some significant changes to make it less prejudicial. And following up on what was just discussed, that may be the starting line for getting at rules like this, which is starting the states, because the states that are seeing people over and over again, they may have a stronger sense of what the problems are than the federal system that has relatively few jury trials, and the stakes are generally, by the time you get to trial, the stakes are so high for federal crimes that you're definitely at plea, regardless of whether or not you're going to testify or not. So yeah, but great question. Thank you. No, there's not a trend yet, but a lot of discussion, both among social scientists, interestingly, and lawyers about whether what are we getting out of this rule? Does anything support it?
Thank you. I believe we have a question in the room live.
Yes, we have a question for Professor Chin, and it goes as follows. Thanks for an illuminating presentation. I agree with your analysis, but wonder about feasibility. Congress is in its Republican-led paralysis. It's unlikely to take action to review these laws. Sovereign states are similarly unlikely. Do you think California, the laboratory for progressive policies in the US, would be willing to take lead on this issue? Thank you for your thoughts.
You're on mute, Professor Chin.
Sorry. My argument is about judicial review, and so it's an argument to the courts and to the Supreme Court, and again, the states can do this their own way if they want, and the U.S. Supreme Court has its characteristics and a conservative supermajority, but I do think that they are interested in not appearing to be racist. And so I think that there's some possibility that just as every now and then Rehnquist would offer a surprise, that there's a possibility that the Supreme Court would say, we're not going to be soft on historical racism. So I think it's conceivable. In terms of whether states would actually do it, I think it depends on whether they're going to be encouraged to do it by an addition to judicial review, and if the courts say we're going to take this into account, then states will do it. Would California do it? I do think there might be some states that would do it. It's a big undertaking. But to me, that's the reason that it's important, because if you ask the question, how much are our current laws affected by racial discrimination, and the answer is we don't know, but maybe it's a lot, then it seems to me that it's worth investing in answering that question.
Thank you. Are there any other questions in the room? No. So I'll ask one last question with our 2 minutes left to go, right? For Professor Ramirez, as with everything, COVID had a vast impact on all of areas of our life. How did COVID impact the implementation of your program, and what happened during that period to newly released individuals?
It was really hard. A lot of people were released during the COVID period because of crowding in the jails. But it was hard. People weren't coming in person. So a lot of things had to be done by phone. A lot of counseling was done by phone, and we had to look at ways to do, for example, substance use programming virtually. But we are now back in person, and it didn't stop the development, but it did hinder it.
Well, I thank you so much for the panelists. We probably could go on and on and on all day on the race and criminal justice topic. Thank you to everyone who's online attending. I encourage you to come back at 1:15, where we'll reconvene for the Center for Social Justice presentations on their social justice initiative in Western Mass. Thank you to the panelists, and thank you to everyone in the room.
Thank you.